theorizing. Thank you.
I guess I need this.
Okay. Hello, everyone. Welcome back. My name is Sebastian. We are going to be hosting the last session of today, Deep Tech Lounge, Tartu Startup Day 2025. Very excited for this last conversation with Chris and Siim. Give them a big round of applause. Yes, yes, we still have people here switched on and eager for this conversation. I'm really excited for the insights coming now today on the topic of NDAs. And we'll be joining you too, actually. So maybe can we start with you, Siim? Can you give us a little bit of background on who you are and what you do?
So hi, I'm Siim Kinnas. I'm the head of Technology Transfer and Intellectual Property Office at Enterprise Estonia.
Brilliant. What about you, Chris?
I'm Chris Goddard. I'm a partner with Dehns. We're one of the UK's largest firms of intellectual property specialists. Personally, I'm a European patent attorney. I qualified about 20 years ago, too long ago to remember really. And since then, I've worked with, I'm a chemist by training, so mostly I've worked with sort of chemical, pharmaceutical companies, all the way from universities and startup companies right through to big pharma companies. And one of my kind of great things about the clients I've had is that they've stuck with me for many years. So I've often been with them for 10, 15, 20 years and got to see them all the way from university professors through to being bought out for billions of dollars by giant pharma companies. And, you know, it's a great ride to be able to follow them along in those kinds of things. And you get, you know, quite a lot of background in the things that they need along the way.
Well, actually, sort of that's a good point. Sort of, I said who I am, but not what I do. So basically, what our unit tries to do is sort of help companies figure out how to make money out of knowledge, pretty much. Sort of, if they have the intangible assets, sort of how to commercialize that and put it in the real world. And sort of one of the main issues sort of that we are sort of here to talk about is sort of how to handle confidential information, sort of between different companies and between different people, basically. Do you have a question? No, not yet.
Not yet,
Okay.
no.
So we actually asked Sebastian to be here as a representative of the startup community, sort of to put in his 2 cents, because sort of we wanted to have a talk here. And what we wanted to discuss are basically sort of the stumbling blocks around the NDAs, because sort of we see quite often that NDA is a little bit like this mythical creature that, oh, I'm going to sign an NDA and somehow sort of this will protect me. But the NDA, well, they are not like runic markings on some mythical dwarf wall sort of to keep everyone out. There are rules to the game, basically. Sort of, would you mind sort of explaining what those rules are?
Well, essentially an NDA is a contract, and so it needs to adhere to the sorts of rules that you need for a contract. It needs to be clear who's involved, it needs to be clear what the purpose of the contract is, and you know what it's supposed to cover. And as with many contracts, the better, the more specifically you can define these types of things, the better the contract is, not only in terms of whether it can be enforced if it comes in front of a court of law, but probably, particularly with NDAs, more importantly, is whether it can be put into practice by the parties, because the point of an NDA is that certain confidential information should be not disclosed. That's the clue is in the name there. And so it needs to be arranged in such a way that, that essentially all parties understand what behavior should happen and what should not, what should be disclosed and what not, and you know what the limits on those things are. Because if you don't know the limit, it's very difficult to tell what falls inside it. It's a bit like a patent claim in that respect.
So one of the actually scariest bits of statistics that actually comes from Dehns is that Dehns did a research for, I think it was the European Commission, or Elisa?
I think it may have been,
yeah.
Yes.
Where they looked at sort of how many NDAs actually survive a court case. So when one sort of 2 parties have done an NDA, and then sort of one party accuses the other one, sort of, dude, you did something with the information that they gave you that I did not allow you to do. And out of those court cases, only about 27% actually are successful. And most of those court cases that fail because the parties failed to identify, for example, the confidential information in a way that sort of is defensible. So how should we sort of, what are the things that we can learn from that?
Well, essentially, really to be as specific as possible in all of these things. I mean, the first thing, for example, is, who are the parties to the contract? And are those parties actually represented? Because if the contract is going to be effective, it has to be executed by someone who's authorized to do that on behalf of the parties. If you take your contract to a court of law and it was signed by somebody in the research department who has no authority to sign on behalf of the company, court's just going to throw it out right away.
Well, actually, there's also the reverse is also true. For example, that we see with, let's say, academical institutions is where someone high up in the legal department signs the NDA because that's what the law requires of them, but no one tells the professor. So the professor does not know that they should not show the information to the students or other professors.
Exactly that, and that's the other half of the kind of specificity is who are the parties in the sense of who actually has to carry this out. And the people who have to carry it out have to know about it. And yeah, it's no good, and that applies in many senses because yes, it could be signed by somebody high up and the people at the coalface don't know about that, but equally, what if it was filed 10 years ago and it was signed and then the researchers have been and gone and, it's 3 generations later, how do they know that there was an NDA signed 10 years ago by their predecessor's predecessor?
And then suddenly a letter arrives. You have disclosed our confidential information. Like, who are you?
Yes. What confidential information is exactly that? And similarly, you want to be specific about the purpose that the information is to be used for, because if company A employs company B to do some collaboration, some project for them, and they pass on confidential information, if the researcher doesn't know that that's confidential to their client, to party A, then when party C comes along and says, do a project for me, they may use that information from their previous collaboration because, they just didn't know that was confidential to somebody else. And this is something that Siim and I were saying earlier, is when you mark your information confidential, maybe you should mark it confidential to company A. Because then when company B's employee reads it, they kind of think, oh, maybe I shouldn't share it with this competitor or what have you. Because, yeah, if it's confidential, is it confidential to me or them or somebody else who quite knows? So, yeah, it's specificity and control is the other thing that I think is key, is to try to control who has the information. I mean, the simplest thing is the fewer people you share the information with, the less likely it is to be spread around. So can you control how many people it's shared with? Can you control what they do with it? And also, can you control how long this is effective for? So lots of NDAs are just interminate. They will go on forever. But actually, as I say, years ago, will you know? And when it comes to an end, is there a clause to say what happens to that information? Will it be returned or destroyed? Do you have a clause that says the secrecy must persist so that people, obviously you can't destroy the information in people's heads, but hopefully they should know that they still shouldn't share that after the contract ends.
So as a best practice, what we should see that in the NDA you had really specific lines like what is disclosed is this, like really specific information. And every time the parties in the negotiation, the collaboration need additional information, you should come back to the original NDA, maybe add to that or make sure. Because in the end it falls down to what you can prove in court, what you agree to. But you should make following the agreement as much of a no-brainer for everybody in your company as possible. So you shouldn't make it like impenetrable wall of legal text. But it should be, what is disclosed? Who is it disclosed to? Like how? Like is it a document or a USB stick or a PDF document or what? And who gets access to it? Under what conditions? And that's pretty much it. And and the time as well. During which period? Everything else is details, really.
Absolutely. And the great thing about the time period is then you can refresh all that information. So you go back to it, even if the NDA is renewed, that's fine, but you can renew it on the basis that, well, now these people have left the company, they're not relevant, these new people have come in, they need to, and hopefully you can get them to acknowledge that this NDA exists. Maybe you send a copy around and you get them to endorse it. I've read and understood this NDA, a researcher. And then the research shows that when people are on board with the idea of confidentiality, they're very disinclined to reveal that information. If they understand that it's illegal to do so, then they will very rarely go against that. Much more of an issue is the unintended, the accidental disclosures. And so keeping people engaged, giving them that mental understanding that, you know, this represents a trade secret, this represents confidential information of any sort, is really the key to making sure that actually you don't need to then have a judicial remedy for this.
I have a good question for you guys. So, having spent the best part of the last 10 years helping founders to connect with investors, mentors, large corporate companies and governmental agencies for a lot of their work, right? Often very early stage companies. The question of should we sign an NDA does come up, especially for companies that work like towards deep tech, right? But for a lot of the investors that I spoke to in the last couple of days, there's many investment firms that say, I won't sign an NDA. I'm talking to so many different companies, a lot of the things that you're going to share with me. I'm talking to portfolio companies, to potential new investments. I just won't sign it. How should early stage founders or people in the audience that, you know, are working on something that's very innovative but might not be a trade secret yet, distill whether it is worth signing an NDA before specific calls and specific meetings, or whether something is just going to be industry knowledge?
Well, I think the key there really is to try to, again, be as specific as possible, because an NDA doesn't have to be, you know, I will be secret about everything forever. And this is the thing, be as specific as you can, and then perhaps it's worth it on both sides, because that's not holding you down to prevent you from talking to other people and these kinds of things. All you're signing essentially is to say, you know, I will review this and I won't share what I see for this very specific piece of information. And yeah, next time you'll have to have a new one, but they're much more likely to accept that as long as it's, you know, very specific in terms of time and content. Do you agree with that?
I would actually sort of take a different approach to that. Sort of, I do try to run on the sort of on the basic principle that do not make it hard for you to people give you money. So basically, don't make the process any more difficult than it needs to be. And yes, it's true that some investors sort of really see like tens of proposals each day, and even if they would want to, like, signing those sort of gets repetitive and boring. So it might make it easier sort of if you as a company sort of decide straight up before you go to the investor sort of what you will keep for yourself. So like the nitty-gritty and the details, technical, sort of you keep those to yourself. But what the investor anyway would like to see is basically how are you going to make the money back for them. And sort of you can make like this non-confidential deck, and everything sort of once they are hooked and say, yeah, I want to talk to you later. So now they're invested and they would be ready to sign an NDA to go deeper. But again, sort of measure sort of what information do they really need to assess that, and sort of don't give them more information than they need.
I absolutely agree with that, because that comes back to the question of share with as few people as you can. And the fewest number of people you can share with is none in terms of your confidential information. So if you can avoid sharing something that is confidential, then absolutely that's the best way forward. And you know, if you have to share it, then yeah, share the least you can and be as specific about that as you possibly can.
And how do you see like the kind of response that you get as soon as people start to bring the word NDA onto the table? I'll give a very specific example. I was preparing for some of the discussions that we've had on this stage over the last couple of days. One that we had yesterday was related to patent and IP. And before jumping on the introduction call with the founder of the company, I had an NDA request in my inbox and said, I will only get onto this call to start talking to you about what we will be discussing if you sign the NDA. And I think when I looked at the document and the NDA itself, right, it was quite specific. It was fairly straightforward and nothing extraordinary, but just the kind of, I have an NDA in my inbox and that person won't talk to me unless I sign the document, gives off a certain vibe as well. So when is it required to actually do that? Isn't it like intimidating for companies? And to your point, Siim, of like ultimately you don't want to make it harder for yourself to be able to have some of those conversations. How do you see that, and how do you advise companies?
So it all comes down to the sort of what kind of transaction or interaction we are sort of looking for here, sort of with the other companies. Sort of in your case, sort of in preparation of a public talk, really. I do get the sense that you were being trolled. I'm sorry.
Sure. Yeah.
Well, yeah, absolutely. I can't see. I can't see how a discussion about something that's going to be discussed in this room can possibly be confidential. And this is the thing: is NDAs are for confidential information, and I think often it's easy to lose sight of that and just say, well, we must have an NDA before we can speak. But Siim's point is absolutely right.
It could be also that they were maybe preparing for some sort of bigger, like an event or a deal or something that sort of he might have been maybe sort of unsure about himself, maybe that so they weren't sure what's going to be public or not in the near future. It could be. Yeah, we might sort of, if we find him here, we can actually sort of ask him.
I think Ola was joking actually, but I think the idea of like, yeah, the vibe that it gives into the conversation, then all of a sudden you're like, oh, okay, this is going to be a serious talk then. Like, if the NDA is there.
Oh, that's true. Yeah, that's marketing basically.
And that could be good or bad, depending on what vibe you're trying to bring to the conversation.
Yeah, I remember back in the university days where we were trying to get companies come to work with our scientists. So there was one case, for example, where a company came and said that I have a sort of, I want to work with your scientists, but I won't tell you with whom and what for before we do an NDA. And sort of, dude, our lawyer's time costs something, so what? And he was really adamant, sort of to the point where we just got curious and said, okay. Turns out that the idea itself was actually pretty interesting, and we weren't actually sort of technically able to do that in the end. But sort of, as an opening, sort of, I don't even know what you're selling me. So we come back to like sort of what you get like the pitches to the investors type of thing. Sort of, I can't even know what you're talking about to me without an NDA. Sort of, it seems a bit superfluous.
And again, I think, you know, that's the kind of situation where surely they could have distilled out something that was not confidential, that could have given you some kind of perception of where they were going. And it's very easy to get the feeling, I think, when you're new to this, that everything has to be confidential. But actually, of course, confidential information is only information that's not available through other channels. And it's easy to lose sight of that, actually, you know, the name of your company is not confidential because it's on your website. So you don't have to have an NDA before you can tell people
So this is actually a very good point in that sort of, that's one of the ways how you can destroy novelty and NDAs and contracts as such. For example, in court cases. So for example, that if something falls out of definition during that process, sort of, then but it is still included inside the contract, but it's not confidential anymore, then you can be attacked. But so it's a thing that is not confidential, but it is in this list that you say is confidential. Hence, this list is bullshit and not null and void, and should not be granted any kind of protection anyway. And so the court says, yeah. Problem, yeah, and that's how you lose confidentiality cases, basically. So I've seen colleagues in the US, for example, that there was a rather amusing sort of conversation back in the latest Licensing Executive Society International Conference, where the US and UK lawyers were arguing which is the better strategy. Basically, do you keep sort of say that everything in your company is confidential, and you pick the things that are not, and those are the things that you publish, or you have this specific list that are confidential, only talk about those under NDAs, and sort of everything else is whatever happens. And you attack them the exact same way. So you say that, I found this thing that looks like a confidential thing. It is not in the confidentiality list, hence the confidentiality list is moot, and vice versa. So you need to be careful about that. But I think one of the things that we need to bear in mind is that on the European continent at least, so there are slight differences in the UK and US law, because that's common law, and the European law, which is usually based on main German law, where the confidentiality agreements are mostly viewed in the context of trade secrets, and trade secrets need to basically adhere to the 3 points of the definition. So it needs to be secret, not generally known. It needs to have business value because it's not generally known, and the company needs to have done some sort of reasonable effort to keep it a secret. And that's the point where usually companies fall face down, that they do not do the reasonable effort. So when they say, oh, this information was terribly, terribly important for us, but dude, you left the paper outside on your secretary's desk. How important could it have been to you? So that's an actual case that happened. Or when there's a very interesting case in Estonian Supreme Court, where a company accused a former worker of infringing or sort of disclosing their trade secrets. And in the end, the company had actually had the worker sort of sign a paper that, yes, I have been instructed that this is a trade secret, that I cannot divulge it anywhere. And the court decided that because the person who signed the agreement was not Estonian, and they said that I did not really understand what I was signing. The company had not made reasonable effort to make sure that information was being kept in a reasonable way. So they lost the case. Yeah.
I think even identifying what the secret is often a step that lots of companies don't really take seriously enough. It's quite easy to say, oh yeah, everything that comes out of the lab is trade secret. But surely there are nuggets of information in there that are really key to your business, to your technology, and you need to be able to identify those if you're going to claim that they're trade secret. And that does mean that you need a certain formal process to be able to identify these, and like any kind of relationship, you need to maintain that. You need to kind of keep that updated, keep the list of who should and shouldn't have access to this information and so forth. I mean, it doesn't have to be in a really formal way, but if you have a little spreadsheet that has, these kinds of things on, that's a lot better than just saying, oh yeah, well, everyone understood that this, was our trade secret. Well, not everyone necessarily has the same perception that you do.
Not everyone was in that room.
Exactly so.
I think it's very interesting to hear kind of what you're saying and seeing a lot of parallels with the conversation we were having yesterday on the discussion with IP and patents, because I think the definition part, it remains key and kind of the first step. And then I think our speakers yesterday was mentioning that once you've defined very clearly where that IP lies and what's actually very special or a trade secret for you, then you can make the decision of either patenting and then doing it quickly because you've identified that this is really a huge USP and it's something you need to protect, that you would put under NDA and reveal, as little as possible, or that you would, in that sense, like patent. And then for the rest, you would very much keep it for yourself. Don't leave it lying around. Don't share it with more people than it needs to be shared, and make sure that that's going to remain your secret sauce that the investors really want, but don't get their hands on until it can be patented.
That's actually a very important point, because sort of one of the conditions of patenting is secrecy up to the point of filing the patent application. And oftentimes that we find with companies is that they want to maybe test the prototype with clients and customers, but that is considered publication. And the only way to keep that from being a publication is an NDA, basically. So that's, the patents are like the flip side of the coin of the trade secrets, yes, absolutely.
Absolutely, and it's important to emphasize that it's just the disclosure to your friend that here is the potential disclosure that might destroy your patent. Not if they go off and tell the world. It doesn't matter whether they do that or not. If you've disclosed it to them under circumstances that are not confidential, then that's a public disclosure, and that can potentially destroy the novelty of a patent that might come after that.
And maybe one more sort of, we are all doom and gloom here about NDAs are shit. But basically, sort of one more sort of nail into the coffin is about sort of, well, how do I basically make sure that the people don't really want to sort of go against the NDA, sort of make sure that they really want to enforce it in their own house, is sort of court-wise or legal-wise, the only thing you can do about trade secret and losing a trade secret or sort of breakage of the NDA is, once it's out there, you can only go to court for damages. So if you need to be able to prove damages. So before that, there is sort of you can put like the price on breach of contract. So and sort of that also actually falls under the definition of reasonable effort. So that breach of contract fine cannot be unreasonable, or sort of, I don't know, like 2 million euros for like sort of a new formula of nail polish. So they need to be proportional. So that's something that we need to bear in mind as well. So it might very well be that startups, they think that they have some humongous and very valuable technology when they go to the investor and sort of finally get to the NDA stage. And then they write sort of to the investor into the NDA, yeah, if you talk about this, it's like 2 million euros fine. And whichever court would look at that and say, that, come on, your technology is at best 10K, come on.
And that again ties back to the trade secret legislation and the fact the EU directive on that says that remedies must be proportionate. And that's, if you don't have that proportionality, then it's not going to be upheld. But the research seems to suggest that having a numerical value on that recompense is a very good thing to have in your contract, because well, then if you have something that says, they'll rectify any losses, direct or incidental from the breach, well, who is going to be able to calculate what that should be? But equally, if you've got someone who's engaged in that, your researcher or what have you, they may or may not put an appropriate value on that. They're probably not involved in the company. They probably have no real idea what this information is worth or not. But they understand what 100,000 euros means, and this kind of thing. But also, maybe you need to think in circumstances, well, if there has been a breach, do we need to go straight to the court, or should we have some in-between measure of should there be some mediation? Should there be some negotiation? Should this say 100,000 euros or such sum as is agreed between the parties? Because maybe you would rather have 50,000 euros and keep the collaboration and not have to pay all your court fees and so forth than have you 100,000. And maybe your collaborator would rather that as well. Most disclosures are not intended, they're accidental.
Absolutely.
And perhaps both sides can carry on working together if it's not too adversarial. So it's not, it doesn't have to be the case that you disclosed my information, I'm going for your throat. Maybe there's a middle ground sometimes.
Yeah.
I guess as our time is coming to an end, I would like to ask you a last question, like to wrap up. And end on a positive note as well. Any pieces of advice for people here in the room that will be having to use NDA in the future, or are under NDA with some of their clients, and things might not be going the way that they want to? Like, what's kind of the essential piece that you would like to share with them?
Well, I don't know about if it's not going the way you want, but I mean, NDAs they're not difficult, they're not magic, there are good templates out there, but kind of personalize them, be specific about it, as we were saying. Try to maintain as much control as you can throughout the process, and be as specific as you can, and then hopefully you have something that's useful to both sides, is not onerous to put in place, and is actually of some value as a contract. So yeah, use the resources that are there and don't be frightened of them, I think.
Yeah. Basically more of the same. Identify what you want to share, or what it is that you need to know from the other side, so the other party can weigh if they are comfortable with sharing that. Identify how that information is exchanged, for what happens after the collaboration with it, and who gets access to it. So when that's all said and done, and in the contract, I'd say you're 90% there.
And if there's any remaining questions, then they can come and talk to you, Siim, right?
Yeah, absolutely. Yeah.
Brilliant.
So 5 hours of free consultations for every Estonian company. So, yeah.
Here you go. You heard it. 5 hours of Siim's time to make sure that you don't make a mistake that you will regret later on.
Always get a CTA in there. Yeah.
Great. Thank you so much, guys.
Thank you
thank you
very much.
everybody for your attention. Enjoy the rest of Startup Day. This is wrapping up our last conversation of the day. It's been 2 days of a lot of great insights. Luckily, everything has been recorded. It will be published by Enterprise Estonia, so keep an eye out on their social channels for those episodes as well. And until next time, thank you so much.
Thank you.
Thank you.